the next part of the summit is really to get a deeper dive into what actual initiatives are being proposed in the legislative session. I'll give you a heads up. People have said there's no way we're going to be able to have all these presentations in 1 hour and get through it, but I have total confidence in these people and I know they can do it. We have some backup material for you, including briefing papers. They are linked to the agenda itself. We are very grateful for the participation of not just one legislator, but many legislators in this morning. Their insights and knowledge of state resources is indispensable. And they have agreed to sit through the next section and contribute. And so we are grateful for that participation. I would like to open it up and just explain the format just a little bit. We've got literally 6 presentations, 10 minutes apiece. They're the first 4 issues that we'll be talking about. We have legislators that are sitting on specific bills. And so we're asking the legislators to comment why they are carrying this bill and why they think it is so important to get this legislation passed in the upcoming session. We also have coupled them with individuals that have more have in-depth information and about those issues and who can share some of that with you today. We do have an intern who's going to be sharing PowerPoints as we go along, and we will make the PowerPoint available as well as this recording in the future if people want to revisit it. I ask all the speakers 10 minutes, not individually, but 10 minutes per issue. So we will have one intern who is notifying our speakers on a particular issue when they have 1 minute left. We're hoping to get through this. It's not intended to be an in-depth discussion of all these issues. It's really intended to be a starting point. And we want to see your chat in the chat, your questions, and we will try to follow up and answer those questions if you have them. So let's get started. The first issue is the Comprehensive Student Support Program. And Representative Robin Shackelford, would you please open that discussion up?
Okay, thank you, Janae. So this piece of legislation, I think, is profoundly needed. As we look at the research, we already know what we discussed today, that our students definitely need those support services that deal with trauma, that deal with their mental health that's going on in their families and friends, whether it's they had their friends slayed by gunshots, their families affected by drugs or divorce. We know that a lot of them are experiencing so much trauma that is affecting how they can get educated. So what this bill is going to do is just try to make sure we fund and have a grant program for those school counselors, school social workers, school nurses and psychologists, and have them working on the students. But one more thing I just wanted to say about the problem that exists here in Indiana with the lack of support for these professionals in schools is looking at the national recommendations on how many of those school counselors or social workers or psychologists, looking at that ratio on how it should be per student. And if you look at the national recommendation for school counselors, for example, it should be 250 to 1. Currently in Indiana, we're averaging 533 to 1. So we definitely do not have enough school counselors. When it comes to school social workers, the national recommendation is 250 to 1. But here in Indiana, we are averaging 4,639 to 1 student. That is 1 professional for all of these students to take care of. And then for school psychologists, which the recommendation is 500 students to 1 professional, we are averaging 2,324 to 1 when it comes to school psychologists. So there is definitely a problem that is not being addressed. I think it is a problem that has been going on for a long time, but now I think it's definitely the perfect storm between what is happening in our schools and in our neighborhoods, in our community, not only in Indiana, but worldwide, where we need to focus on these services for our students. So what the bill will do is actually set up a grant program for some of those schools to increase the staffing level and come up with a team approach for one between the counselors and social workers and psychologists so they can be put together. The grant program will be for the school corporations. So we're looking to assist and improve on the student support staff ratios and to establish comprehensive student support teams to help improve a multi-list of things, which include school climate, school safety, student academic success, the outcomes for crisis intervention, emergency preparedness, and an integrated approach advancing positive school discipline, culturally responsive, and trauma-informed practices. So we are hoping that we will be able to get this pushed through. We have seen the lack of professional development, the lack of professionals and our teachers getting that trauma-informed care. As we mentioned earlier, only 59% of our school employees actually receive any professional development when it comes to trauma-informed care. There is a lack of student support services. Only 57% of our schools employ a corporation level coordinator for school emotional learning or any type of mental health specialist. And then there's a lack of sufficient funding and access to qualified workers. So we don't have that many trained mental health professionals actually in our schools. That rate looks like about 71% that we're lacking there. So this bill will help address a lot of those issues and concerns that we've been working on. Advocacy will be definitely needed, as it is for all these bills, but in particular from those students and from those families that are being affected. This will greatly help if they hear directly from the people being affected and the school administration. Because I'll just give this personal insert. In one of my school tours, I mentioned in the chat that I go on my school tours every other year before budget hearings to see what their needs are. And last tour, trauma informed was one of the highest things that we focused on. But the lack of school nurses in mental health is so, I would say, large over here on the east and far east side. They're sharing a nurse. The nurse may come in once a month, once every other week. And then I heard from some administrators that a lot of our kids have to take medication that they don't feel comfortable in giving the medication. A lot of this medication is not just taken by mouth. So, and it's up to them, the parents bringing this medication. Medication is supposed to be given during school time, but because there isn't a nurse there, then they're having to administer this medication, or the responsibility is put on them. So there are so many issues that affect our kids while they're trying to learn. And the support services is just one area that we're trying to get more funding for and support for.
Great. Thank you, Representative Shackelford. Christy Goss.
Yes, Representative Shackelford did such a good job of giving an overview of this program. I think if I could just go back 2 of my slides, there's an iceberg slide, and I'll land on the why of this program, the heart of this program. And you'll see here, I've got a quote. It says, the most obvious symptom is not necessarily the problem. Keep this in mind for everything you see. And I'm going to give a shout out to Christopher, actually, who was speaking about getting to the root cause of things. And we in our schools, we're so often, hitting at things above the surface, behavior. We can kind of go on and on, right? The obvious symptom is not necessarily the problem. Keep this in mind for everything you see. It is so often the symptom or crisis to which we respond. It is crisis that often draws all the attention of our resources and funding: school safety, behavior, bullying, and school to prison pipeline, suicide, mental health, substance use. We can go on and on. What do these things have in common? They're all things schools are asked to address on top of academics. They are, but they're also us responding to crisis. How do we move away from pouring our resources into responding to crisis and move to prevention, and more importantly, to the promotion of whole child well-being? And that is ultimately the intention of this legislation, to get to what is underneath the waterline here in this picture and get to the root cause of all these different issues mentioned above, which ultimately also affect our community outcomes like workforce and health outcomes. And the beautiful thing is that with the growing research coming from the fields of child development, and specifically about how the brain learns and develops, the same root causes that help us to address these issues also help us to create the conditions for learning. But we need that expertise at the table, the people with the backgrounds that really can sit beside our educators and bring that holistic focus to how we address all the issues that Representative Shackelford just spoke about. And CPLI has done such a beautiful job, as they always do, of building a broad coalition, including representatives from all of our state associations, including school counselors, social workers, the nurses, school psychologists, school resource officers, and then expertise from people like Dr. Recidivism, who really bring in that lens of how we look at this through disproportionality issues, culturally responsive issues, and the like. So I'm very grateful for this legislation.
Thank you, Christy. I think our Representative Shackelford, did you have any concluding remarks you wanted to make?
No, I think we've done enough.
All right, thank you so much. We're going to move on to our next issue, right on time. Minimum age for juvenile detention. Representative Pryor.
Thank you. So the reason why I'm carrying this bill is because I think it's a much needed bill. Indiana, in the state of Indiana, there's no minimum age for a child to be held in a secure juvenile detention facility. And because of that, children as young as 9, 10, or 11, and even younger may be held in a secure detention facility. And it's been shown that this could increase recidivism, and it also has a lasting harm and behavioral consequences for the child that is held in those secure juvenile detention facilities. Any length of time that a child is away from their family, away from their loving family, I would say, and in a facility, it impacts that child's mental and physical well-being, delaying their education, particularly if they're moving from place to place, and if that juvenile facility does not have the adequate educational staffing there to educate that child and to keep them at the level that they should be educating them at, causing lasting psychological trauma to the child, having a 9 or 10-year-old in a juvenile facility with a 16, 17-year-old, jeopardizing their future employment perspectives and opportunities that the child may have, in exposing that young child to a risk of violence that may occur as well. So detaining children is not that young, is not something that is going to help that child. What it does do is pose a threat to public safety, as it leads to increased rates of crime and recidivism in minors, which is the complete opposite of what we want to do when we have children who are involved in these situations. One thing I think is important as well is to make sure that kids have as less contact with law enforcement and juvenile facilities. What we don't want to do is to have the young people feel that these type of facilities is their safe place or a place where they feel comfortable at. And so when you're putting a younger child in those type of environments, particularly for extended periods of time, that is not going to me, bode well for the longevity of that child. And so why establish a bill, or why have a minimum age for a child to not be in a juvenile detention facility? Because young people are at greater risk of being victims when they're in custody of these juvenile detention facilities, for one. For two, the child can be served by a variety of placements that are safer and more effective and less harmful to the child that is in a detention facility. And then the other thing is detention increases chances for recidivism and poor outcomes for the child. As I stated earlier, the criminal justice system should be a system in which people come out better than what they were when they go in. However, unfortunately, we have gotten away from that. Young people who are in juvenile detention facilities, there's a constant fight between the state and local government as to who even pays for the education of students who are young people who are in juvenile detention facilities. There's, issues with that. And so just getting our kids educated so that once they even get out of these facilities, they're able to be productive citizens, and they're adding to the economy and not taking away from the economy. We just talked about having records sealed and expungement, and we want to put kids on a path of success. And if we're getting young people as young as 9, 10, 11, and in some instances younger than that, going into juvenile detention facilities, we're setting up our young people for failure. And I don't think that is a situation, that's not a situation that I want to put our kids in. And we have to look at how we are better preparing our kids and their families as a whole, looking at the situation from a holistic perspective, so our kids are not even getting caught into a situation where they are being put into a juvenile facility or committing a crime in which they will get caught up and be in a secure facility for any length of time. So with that, I think I'll be quiet. I think I've covered everything, and I answer questions if I have time in my section.
Thank you, Representative Pryor. I want to do a special introduction of Abby Winslow. Abby has been an intern with CPLI since August. She's concluding her internship today, and she's also graduating from Butler University. Anyway, Abby, thank you so much for being a part of this, actually being involved in our work this semester. It's been a joy having you as a part of our team. And would you please conclude this section for us?
Of course. Thank you, Janae. As she said, my name is Abby Wenzel, and Representative Pryor really nailed it on the head. Lindsay, if you wanted to take it to the next slide, I can talk about the current Indiana law. It states that Indiana law recognizes the dangers of detaining young people. Indiana has a statute that prohibits juvenile status offenders from being placed in detention centers pre-adjudication, which means pre-trial, as well as a statute that requires a child to be at least 12 years old to be committed to the Department of Correction or the Division of Youth Services. So you want to go to the next slide. However, Indiana, there is no minimum age for a child to be held in a secure juvenile detention facility. So what that means is that any length of the detention will negatively impact the child's mental health, their physical well-being. This includes delaying their education, causing lasting psychological trauma. This jeopardizes their future employment options and really exposes the young children to significant risks of violence. And confining these children in the facilities is not developmentally appropriate at all. When we compare a child's brain to an adult brain, we have much less white matter, which is the connective wiring that helps information flow from one part of the brain to the other. So that means when adolescents are making decisions, they rely heavily on the emotional center of their brain for decision making, reacting to rapid firing, pleasurable, emotional, and rewarding sensations instead of, okay, what is this consequence gonna be? They don't think about that when they are making these decisions. If we go into the next slide, there's gonna be a graph on the right-hand side. And as Representative Pryor said, there actually has someone in the Indiana juvenile justice system been in a detention facility as young as 8 years old. At 8 years old, you are in about the second or third grade. So if you try and think back to the second or third grade, there aren't too many memories that I can personally think of that stand out. So in this chart over to the right-hand side, there was a study done from the Indiana Department of Corrections. And it says that it was completed over the course of 3 years, started in 2015, ended in 2018. And it says that the Indiana Department of Correction released 688 students from the Juvenile Department of Correction. Of those juveniles released, 33.3% were re-incarcerated with the Indiana Department of Correction within 3 years of their release date. The table also details recidivism, which means that they're going to reoffend. Recidivism means reoffending, and it is shown that it is increased and it does have a lasting harm and behavioral consequences for these young children. The percentage of returns from 2015 releases that at 1 year, 2 year, and 3 year milestones for the males and females. So by 2018, 34.3% of males had reoffended, and 27.9% of females had. Lindsay showed the next slide earlier, but I just wanted to summarize what Representative Pryor had said, that we need to raise the minimum age of detention to the national best practice, as the Annie E. Casey Foundation states that the initiative recommends prohibiting the detention of children under the age of 12 in juvenile facilities, which is the national best practice. And Indiana is a JDAI state. So we need to raise the minimum age to at least 12 in order to prevent these children from being from reoffending and not being able to be successful in life. Thank you. Janae, back to you.
All right, thank you, Abby. We're going to move to the issue of jail removal. Senator Breaux.
Is Senator Glick still on the call?
I don't know.
Okay, well, let me just say that so much of what Representative Pryor has and Abby has said about the detention of minors in a juvenile detention center applies very much so with having minors who are awaiting trial to be held in adult court. So we've already discussed much of this, but you know, the essentials are that a child, while they are awaiting trial, when held in an adult court, that could present all sorts of harm and damages. For example, we've already discussed that they're in a place where they could become victimized, which for a child in an adult court already, that's an emotional stress and a burden emotionally that can only be compounded when they ultimately are in harm's way for further victimization by adults who are rightfully being held in that facility. They are not oftentimes young people, when they are in adult facilities while awaiting trial, they do not have access to the services that they need to help them during this transition, in particular educational services, to make sure that they maintain or at least continue to continue to understand the importance of being educated, even though it may not have been of huge import prior to them being in the court system. They need to understand the importance of it, and there needs to be someone who is able to provide them with that understanding and also provide them with those kinds of educational resources. Oftentimes that does not happen, and as Representative Pryor said, many times there are disagreements between the local and the state as to who's going to fund them. So rather than argue, they just don't provide those kinds of services. Additionally, mental health issues need to be addressed, and especially if a young person finds himself in a situation where they are in an adult court, it's because of some kind of circumstance that led them there. Perhaps there is a real need for either mental health assistance or drug interdiction or some kind of service that very likely will not be offered to them while they are in a pretrial situation. And has also been said, these pretrial internments can last 6 months, a year. So you could be looking at a young person who is sitting in a adult court awaiting pretrial for an extremely unreasonable length of time. And so to not have access to any of those services is just really unconscionable. It just does irreparable harm to discard our young people and as if their needs are not different from an adult, when in fact, as Abby has indicated, we know that the brain development occurs very differently in that of a young person. And so to put them in a situation where they are experiencing the same kinds of exposures and potential traumas as an adult when they are incapable of processing all of that, again, does irreparable harm. So what we want to try to do is make sure that while a young person is awaiting a trial in an adult court, and I don't know, do you need to be switching the slides, Marcy? And if so, please do. But what we want to do with this piece of legislation, and there are some financial incentives as well that maybe, Marcy, you can speak to a little bit more in-depthly. But what we want to make sure is that while a young person is in an adult court awaiting trial, that we don't want them to be in an adult court. We want them to be in a court that is going to, in a facility that's going to provide them the services and the resources that they need. And we also want to try to have we want to try to expedite the process so that they are not in there for prolonged periods of time. And I think I'll kick it over to you, Marcy.
Thank you, Senator Brown. So as you were speaking, and there's a couple highlights in the chat, I think we covered a lot of the risks to children, and I think they're similar in terms of kind of having that the youngest children on the juvenile side. One thing I can say, we can criticize our youth detention facilities we'd have a lot of valid reasons to criticize them, but I will tell you the adult side is incredibly, incredibly more damaging to young people, and their recidivism is double or more than what we have in the youth side. So while we certainly still detain too many youth on the youth side, I will say JDAI has done a great initiative in terms of reducing those numbers and more appropriately so serving children with wraparound services in their community. What Senator Breaux was talking about in terms of financial penalties refers to JJDPA, which is a federal law that establishes what we consider to be the floor in terms of states' responses to young people in their care. So in 2018, this law was reauthorized for the first time in 16 years, and it did address a loophole. For 30 years, 45 years, we have required young people with delinquency charges to be removed from adult jails. The law in 2018 confirmed that also applies to young people who are pending adult charges based on the concept that children are innocent until proven guilty. And so it does talk about the fact that states who do not implement this law by December of 2021 will be open to federal penalties of up to definitely 20% for not following the jail removal provision of their federal aid, but up to 40% if the young people who are in adult facilities are not sight and sound separated from the young people that are there. Senator Glick did mention earlier that there are still cases that a judge, upon an independent finding based on 7 factors, could still remove a young person from a youth facility, but there needs to be regular check-in every 30 days to make sure that that young person is adjusting, and if they can be moved back at that point, they should be. Abby, can you switch it to the last slide? There's some questions about how many young people this is. And so I do want to say that similar to the minimum age of detention, Indiana already places children who are convicted as adults in IDOC facilities until they reach the age of majority. In 2018, there were 217 children under the jurisdiction of adult court. Not all of them were in jail. Some of them were out on bond, et cetera. They're typically 16 and 17, but legally they can be as young as 12 in Indiana. So 43, so more than half of the counties had 0 children in adult court over the past 2 years. 40 out of 92 had 5 or fewer children in adult court over 2 years. Only 9 counties had 5 or more children over the past couple of years, and most of those are centered in Marion County, St. Joseph's, Lake, and Elkhart, and then Vanderburgh. So those are the top counties that have more than 5 young people. And I do want to point out that because Indiana is a JDAI state, youth detention population has been shrunk more than 68%. So there is space in the youth facilities to accept these young people who are charged as adults. And just so you understand where Indiana is in terms of the national picture, again, 70% of young people who are pending adult charges are across the country already are held in youth facilities. And there are some counties in Indiana that through individual agreements with their local sheriffs already do house these young people and do so safely. And those young people also get access to the rehabilitative services that are available in most juvenile detention facilities in Indiana. And then the last thing I want to point out here is that there is robust, the only reason we got this into federal law is because we had robust support for this change from various members of law enforcement, including the National Sheriff's Association, major cities chiefs of police, the Council on Juvenile Justice Administrator, the National Partnership on Juvenile Services, as well as many conservative allies who understand that young people, regardless of what their charges, should be housed in a developmentally appropriate system of care. That's why it exists. If Senator Breaux is here, I don't know if there's any last comments from her. I thought she addressed it very well earlier.
No, but thank you for mentioning that site and separation, because that's important as well. That's an important component that needs to be understood, that there is not necessarily site and separation from juveniles, from young people with the adults when they are in an adult court or an adult facility, excuse me.
All right. Well, thank you very much. We're going to go ahead and move on to the eliminating direct file and raising the age of waiver. And Representative Hatcher. Do we still have Representative Hatcher here? I'm not sure.
You might have to do that one, Janae.
I'm going to have Amy Crozes do it. We do have Amy. Thank you, Amy.
Sure. So if Representative Hatcher joins, I would love for her to weigh in because she's very knowledgeable, much more so than I am about this. But I wanted to start with an explanation. So if we can move to the next slide, there are basically really 3 ways for a kid, child in Indiana to be removed from the juvenile justice system and treated like an adult criminal defendant. We have in Indiana what we call direct file, and it's also referred to as exclusion in other places. And then we have two types of waiver. We have presumptive waiver and discretionary waiver. So I want to talk about direct file first and what this proposed legislation would do. Direct file it really means that we take a group of kids based on their age and what they're charged with, and we remove them from juvenile court. So these kids, because of their age and because of their charge, they never see the juvenile court judge. They don't ever enter through that door. So in Indiana, that exclusion starts with kids over the age of 15 who are charged with certain felonies. And so I'm just going to tell you, I've cited the statute there. The felonies on that list are attempted murder, kidnapping, rape, criminal deviant conduct before it was repealed, robbery with a deadly weapon or that results in bodily injury or serious bodily injury, carjacking before it was repealed, and then handgun charges that are charged as felonies. And so what that means is I'm going to give you an example just from an old case of mine on how that would play out. So I had a 15-year-old girl who was sent to Department of Correction. I got her after she was sent there, and she was sent there as a juvenile. So she was tried in the juvenile system, ended up entering an admission. She had a background of things like runaway and truancy, and she and two of her friends who were also juvenile girls were walking around with an unloaded gun that one of the girls had taken from her home. They ended up taking a pair of sneakers from a younger girl who was at a laundromat. So my client was charged with what would be robbery with a deadly weapon. It doesn't matter that it was unloaded or even really if it worked or not. It can be charged as a deadly weapon if committed by an adult. And she received in turn treatment in the juvenile system. So she ended up in the Department of Correction, but as a juvenile. She ended up getting counseling. She caught up on her school credits. She was an excellent student. And when she was finally released from the juvenile facility, she had no criminal record. If this girl had been, instead of 15 years old, if she had been 16, the charge would have been filed in adult criminal court. She would have been held in the adult jail, like we just heard, while waiting trial. She would have ended up with a criminal record, even if she had been convicted or pled to something less than armed robbery. And so we know what kind of consequences an adult criminal record can have on somebody and follow you for the rest of your life. Unlike waiver, which we're going to talk about in a second, the prosecutor and not the judges are making the decisive decision on whether a kid ends up in the adult system or the juvenile system. So it's a charging decision, excuse me. So the CPLI, I saw in the chat earlier, we were asking how many kids are in the adult system, and CPLI put together some briefing papers, and it includes data from the Indiana Criminal Justice Institute's annual report. And so in the 2019-2020 fiscal year, there were 158 juvenile cases under adult court jurisdiction. So here were kids that were treated as adult criminals in that year. This is probably underreported, if anything. So it's data that's gathered, but in some cases we've seen that there are probably kids that aren't being counted. But 85% of those cases were direct file. So in 85% of those, the kids never saw a juvenile court judge. They never got an evaluation of whether they should be treated as kids or adults. They went straight to adult court. Black males are disproportionately the majority of children that end up in the adult system. And so here, a really important figure that we should all probably gasp at is that 3/4 of the kids who were direct filed into adult court were Black, and 15% were white. For waivers that we're going to talk about in a minute, where they start out in juvenile court, 50% were Black. A majority of cases, 56%, did not end up did not result in prison sentences. So these kids ended up getting probation, a community corrections, or a jail sentence. A third of them got probation. And so what that means for us, if we're looking at what is the point, they didn't get the services that they would have got in juvenile court. They got probably less intense services that they would have. They ended up with a criminal history, but weren't scary enough or serious enough offenders or violent enough to actually require a prison sentence. So they're kids that just didn't get the treatment and got the worst of both worlds. So if we can go to the next slide. Like I said, the other way kids can end up in adult court is waiver. And so we have two types of waiver in Indiana. We have presumptive waiver and we have discretionary waiver. And we might presume that if kids start out in juvenile court and a judge looks at whether they should stay or not, that the decision is made after a judge has determined that kid cannot be treated or is beyond help in the juvenile court system. But that assumption would not be correct. So a presumptive waiver really removes most of the judicial discretion, and kind of like that direct file exclusion, it puts the outcome more in the hands of the prosecutor and what charges selected, and the age plays into those statutes as well. If there's probable cause in some cases, under some of those statutes listed, unless the child can prove that it's in the best interests of the child and the safety and welfare of the community for the child to remain in the juvenile system, then the judge has no choice and they are required to waive the child to adult court. With discretionary waiver, that first section 3133(2) is discretionary. In those cases, the judge can determine whether a child and society are best served by the kid staying in juvenile court or by being treated as an adult. And they can look at the individual child and the child as a whole. And the burden is on the state to show why the child should be treated as an adult. So we start with the premise that kids do better in the juvenile system. So if you can move to that last slide. This is the actual legislation that's proposed on waiver. For direct file, it would just get rid of that list. And so kids, if a child is under age 18, they would start out in juvenile and they would get a look to see whether or not by the juvenile court to see if they should be treated in the juvenile system or not. I think that another really important thing to look at when we're saying, should the age be higher for kids to be able to get into adult court? Should all kids start out in juvenile court before it's decided that we're going to treat them like adult criminal defendants? Is that the whole reason we're set up for 120 years, we've had this system to treat kids, and it's based on the concept that treatment and rehabilitation is better than punishment in these cases when somebody's young. And over the years, we've come up with more and more ways to get kids from juvenile into adult court. And really, over the past 20 years, our juvenile crime rate's been declining, but our laws don't reflect that. And we haven't gone back to restore the juvenile court system to its original vision. We've been slow to coming around to that. So this whole thing about treating kids like adults, it's based on the idea of the harsher the punishment, the more deterrent effect that it'll have. And like we heard from Abby, and we've been hearing all day today, kids don't think like that. And so it doesn't have that effect, and it doesn't really work with kids. And contrary to what you would expect or think with these laws, kids tried in adult court reoffend more often and with more serious offenses than kids tried in juvenile court in the same circumstances.
Thank you, Amy. Thank you. And I want to just point out, Marcy, of course, is an expert on this and what's going on around the country. I hope you're following the chat. I think it puts in context that, over the last 15 years, 24 states, as she noted, have amended their automatic transfer direct file laws. And yet Indiana is one of the top states in the country that actually still engages in that practice. And I guess that's one of the reasons why Marcy's so interested in, in being here today and supporting the work in this area. Thank you very much, Amy. We will reconnect with Representative Hatcher. She doesn't join with us for the rest of the program. Juvenile competency to stand trial. Annie?
Yes, thank you, Janae. Hi, everyone. My name is Annie Garrow. I am the co-chair for CPLI's Decriminalization of Youth Work Group. Thank you all for coming to this today and engaging with and expressing support for these important initiatives. So you can go to the first slide. With regard to competency, due process requires that people accused of crimes are able to understand the court proceedings against them and what they're charged with, and then are able to help their lawyers with their case. So Indiana has a standard and process that applies to adults, but our Supreme Court has specifically said that that standard is not appropriate for young people. So when a child in our system presents some signs that suggest that they are not understanding what's going on, or are having trouble communicating with their lawyers, or are struggling with some mental health needs, whatever it might be, our lawyers and judges don't know what to do with them. They recognize that these kids need services, but the criminal system and criminal adjudication does not seem like the right door to get them services through. So these children, they either get stuck in limbo waiting for services that can restore their competency, or they are pushed through the juvenile delinquent system regardless of competency questions so that the judge can get them the services they need that way. So the goal with this statute was to develop a competency process that recognizes the difference between children and adults in terms of competency, and then provides clear standards, clear deadlines, a clear process so that children can access competency restoration services quickly, or if they really are not going to be able to be made competent, they can access services without a criminal adjudication. So you can go to the next slide. We have now had 4 very hardcore policy meetings with a variety of stakeholders, many of whom are here today. I've included this list of the organizations that engaged with us on this topic just to show how widespread in the state the recognition of a need for this statute is, and also to thank the people in these organizations for taking the time out of their schedule to engage with this issue. Throughout my work with CPLI, I've been constantly at how people whose policy is not in their job description for public defenders and prosecutors and probation officers, but they just are committed to making this system better for kids and are willing to work with us on these things. So you can go to the next one. The statute that we came up with, and we have great draft language that Joel Weinecke in large part helped put together. And these are kind of the 6 highlights from it, but some of the highlights are in the definition for competency. We included immaturity as a basis for a child might be found incompetent that way. Sometimes the child is not going to be able to understand the proceedings, not because of any particular developmental disability, but just because they are a child. So in that same vein, we made it so that children younger than 11 are presumed incompetent, and then that can be rebutted. We also established criteria for people who are responsible for evaluating a child's competency. They will have to have specialized training for examining and evaluating children. And then that evaluation process and restoration process will be performed in the least restrictive setting possible and as timely as possible. The really complex part was determining what to do with these children who are found incompetent and will be unlikely to attain competency in a reasonable period of time. This is where the meetings were really helpful. The feedback from stakeholders was really helpful. In these cases, the court has really 3 main options. They can dismiss the charges without prejudice. They can refer the child directly for services, or they can assemble a transition team. One judge present called it a donut meeting, which would be a group of stakeholders. Everyone who's invested in this child or might be able to help this child gets together So people from Indiana Disability Rights, Division of Mental Health and Addiction, someone from the child's school, the child's parents, the child's attorney, all of these people get together and determine what is actually going to be best for this child and what is the most appropriate way to get them those services. So those are the highlights. And if anyone has any questions about this, wants to learn more, wants to give some feedback, I will put my email in the chat and I would love to hear from you.
Thank you, Annie. Thanks so much. We actually made it. Let's see what time it is. 11:04. Okay, Joel Winnicky. Joel, you told me we would not have enough time for you, and we actually are going to give you an extra minute.
Great. I'll be happy to take it. So
You're going to need it.
I'm trying to work on all of these issues that were presented thus far, and also a few other issues that are very important. And so just for a legislative landscape, Senator Tallien's going to be offering a very comprehensive juvenile justice reform package that incorporates a lot of these issues together. But then we're also working with other lawmakers on individual issues that are in her bill, but then also, complement her bill. And those individual lawmakers may have a slightly different take on each of the individuals than Senator Tallien will have. But it's good because I feel like the more that this legislation is introduced by different people, and even if it's in different versions, it'll help us create a better product that is something that's a part of collaboration that we can buy into and create something that can really shape our juvenile legislation. The first thing I'm going to talk about, though, is abolishing juvenile life without parole. We just got a commitment this week from new Senator Yoder, who's in the Monroe County area. She's interested in authoring this legislation. It's also going to be a part of that Senator Tallien's bill as well. But so in Indiana, we have modified our capital punishment to exclude persons under the age of 18. We had to do that because the 8th Amendment prohibits the use of capital punishment on persons under the age of 18. But our death penalty statute also addresses the concept of life without parole. And we've modified that to where it's still available for 16 and 17-year-olds. And then that's the formal way in which kids can get life without parole. But we also see other kids who have been waived into the adult court who are prosecuted for, often this happens with multiple convictions combined together and the sentences that are run consecutively with each other, that those kids get a sentence where we all know and agree that they're going to be in prison for the rest of their life. If an 18-year-old gets a sentence that's going to mandate that they serve at least 50, 60, 70, 80 plus years, they're going to die in prison. The statistics that we've looked at or that have been looked at, I think the ACLU of Michigan did a study. If you get sentenced to a very long term in prison when you're under the age of 18, and especially for persons of color under the age of 18, your life expectancy is probably around 55 is what I remember. So anyway, the 8th Amendment, cruel and unusual punishment, has been applied to kids who are serving life without parole in a way in which mandates a sentencing judge to take into consideration whether their crime was a product of transient qualities of youth, meaning were they just immature, going with the flow, doing something that they shouldn't have been doing at that time, but that's not who they're going to be for the rest of their life, or are they irredeemable or incorrigible? And that is something that's a part of the proportionality clause of the 8th Amendment, meaning that we're trying to make the crime fit the proper, the punishment fit the crime. And one of the inputs that we're going to look at is the individual, and youth is a characteristic of these individuals that can't be denied. Indiana's Constitution, I think, should go even farther because that federal concept of proportionality, it's not even written in the Constitution, but our Constitution has that specific clause written into it. So to me, that means that we need to be taking that one step further and really engaging with this concept of how youth impacts how we sentence persons and whether or not those sentences should last for the rest of their life. So the first thing that we need to do is we need to amend that death penalty statute, the life without parole portion of it, and take away that opportunity for a mandatory life without parole for 16 and 17-year-olds. The second is there's a list of mitigating factors, meaning factors that weigh towards reducing the impact of a sentence on an individual. Currently, it says that if a person is under the age of 18, that should be considered a mitigating factor, and that's statutorily required. Youth is always something that can be considered that's, doesn't have to be defined by statute. But I think we need to raise that number from 18 up to 25 in recognition of the brain science that shows, a lot of you guys have talked about this in many other aspects, but we know now that brains aren't fully developed until that age of 25, probably even after. And we're talking about the very key functioning part of the brain that's the executive control functioning center that's at the frontal lobe, and that's the decision-making part of the brain, the part that we rely upon not to be so impulsive and reactionary, but to actually think through our conduct and what are the consequences, not just for ourselves, but for those around us. And so if that part of the brain is not fully formed until the age of 25, or after, at least we should be looking at that line drawing at the age of 25 to create that statutorily required mitigating consideration. But then the other way that we need to address this in order to prevent, the imposition of, multiple sentences causing life, the impact of a life sentence that can't ever be addressed, no matter how good a person does in prison or how much they're able to show that they've turned their life around. We need to create a special opportunity for these people to be able to modify that sentence, whether it be 15, 20, 30 years on into the future, whatever the legislature is going to be comfortable with. Right now, when somebody commits a violent act and they're an adult, the way it would apply to anybody convicted of a crime. If it's a violent act, the prosecutor is able to have a veto over their ability to seek a modification of that sentence. So hopefully we can take that away just for a limited subset of individuals, the persons who have committed their offenses while they are children. And that way they can have an opportunity to show that they can be redeemed, and it's not just a political decision as to whether or not they have a chance to someday walk out of the prison doors before they die, but if they've truly been redeemed, they can earn their way out. So if we can move on to the next issue, automatic expungement. And we've already talked about that today with a great question that was brought up by one of our youth, and I really appreciate that. So expungements are available for children through juvenile delinquency proceedings. And it's a better opportunity in many ways than the expungement process for adults, because it's a true destruction of records if that's what is ordered. The problem is kids can only tap into that if they file an appropriate petition and get a ruling from the court on that. And I know Marion County helps kids do this, but around the state, oftentimes, there's no statutorily required access to counsel to do this. And so the kids who have the least resources and the least support from their families or other opportunities like that are the ones who are never going to get this expungement. And another thing, a very strong reason why we need to seriously consider this automatic expungement is we've started finally looking at the racial and ethnic disproportionate impacts on youth of color in our juvenile justice system. And we know that at every stage of the juvenile justice system, children of color are being more greatly impacted by the system, meaning they're getting more referrals, they're getting more adjudications, they're getting longer sentences. This could be a very small step in the right direction to actually balance that out and try to limit the continuing long-lasting impacts of what we're, learning more and more each day is a racially disproportionate system. Since we, lawmakers are only going to be comfortable with applying this concept of an automatic expungement to low-level offenses. And if that's where we have to start, that's where we have to start. But I think we need to make sure that we're incorporating offenses that we're typically seeing in juvenile court. Offenses that are not the product of a kid being somebody who's going to be a danger as an adult. So if we're talking about a school fight, that's not indicative of somebody who, we're fearful that when they're 30 years old, they're going to be causing problems in the adult world. That's just a common thing that happens to kids. And so even if it's battery that causes some bodily injury, I still think that should be something that's within the concept of an automatic expungement. All right, I need to move on. I see I'm out of time. Let me introduce the next two things. We need to increase training for school police. And I've seen comments about that today. I'm very glad that we've had those, but not every officer walking into a school and, frequently addressing school issues have to be trained as a school resource officer. They need to be trained in de-escalation, how to deal with students with special needs, dealing with racial and cultural issues. And we've found from talking with school resource officers who strongly support getting this training for officers that to do a basic initial one-day training, we're talking less than $500 per officer. And I think that the benefits that we're going to see as a society from this is going to be much greater than that $500 investment. Once we do that initial training, though, I think we also need to be looking into the future for a recurring process of training. We do that with almost every other professional in the school building. And so why not do that for police as well? And if you could move to the next issue. End cost and fees for families. This is a big one. I see these fees. So a typical juvenile delinquency adjudication, by the time a kid goes through and has to pay for filing fees, probation fees, and some very basic minimum services that most kids get, we're talking they're racking up $300 to $500. A lot of these families in the system do not have $300 to $500. That is a big unexpected expense that could cause a family paycheck to paycheck really suffer from that. And when they can't pay those fees, we see them getting civil judgments imposed upon the parents, and that causes continuing damaging impacts on their ability to get car loans, their ability to get mortgages, so their ability to, really try to navigate in this world that we've created that's based upon that concept of credit. But there's an even greater problem because several counties around the state, I think there's 16 juvenile detention facilities right now in the state. But if you live in a county where you do not have a county-based juvenile detention facility, and you're placing a kid in that detention facility, and I'm talking about the judge, puts a kid in that facility, oftentimes they have to charge the parents a per diem rate for that child to be in the facility. And I see Nancy says 19 juvenile detention centers. Thank you, Nancy. So like the county that I came from as a public defender, I spoke with the judge. His current per diem rate is $175 per day. So if he only uses a juvenile detention facility, rarely, but for a period of up to 2 weeks for a kid, because something's going on, he's got to make sure that society's protected, the kid's protected, and he needs that short-term 2-week long detention to get things under control And then that way we can try to start working the systems. At $175 a day for those parents at 14 days, that is a lot of money. And we're talking, you know, it's probably never going to be able to be paid by those families. Sometimes we're looking at a lot more than that. All right, I am 4 minutes over. Oh, one more. I'm sorry. Make simple possession of marijuana a status offense. Status offenders cannot be placed in detention facilities or the Department of Correction. The reality is for kids of this age range, they don't realize that they can be locked up in such a facility for simple marijuana possession. And I don't think it's good policy for the state to be using those types of facilities for that offense. Do we need to keep kids from using marijuana? Yes, the brains are still developing. We don't want them, you know, getting high all the time. It's probably not a good thing for their health, but there's other things that we need to be doing with these kids as opposed to locking them up. And so now I'm almost 5 minutes over, and I'll stop there.
All right. Thank you so much, Joel. You've been carrying a lot of water these days on legislation, and we really appreciate you. And there's a lot more in that bill. And, you know, I hope we've achieved our goal here today. And we're not trying to make experts out of everybody. These are really complex and complicated issues. But we hope we've done enough for people to see just how important and critical this next legislative session is for children. And we hope that we will be able to keep you engaged and that we will be able to become a voice for change for children in the state of Indiana. There's a lot of good change going on. And this is really a continuation of a lot of work over the last 15 to 20 years. You know, it hasn't just been happening at the national level, it's been happening in our state as well. But I do think that this session opens some doors and opportunities for us to really collaborate around these issues and really chart a different course, as I mentioned when we opened up. We are a little bit over. We have briefing papers that get more into these issues. There is one briefing paper that's called Juvenile Justice Multi-Issue Reform. And if you really want to get a sense of what is in that bill that Joel referred to, that Senator Tallien is going to carry, you definitely want to take a look at that briefing paper.